Did you
Yes.
hear me? I was trying
Yes.
to stop you. Why weren't you stopping?
I didn't hear you say ma'am.
Oh,
People that I
time
work with feel like it was
out.
petty. A lot
Time
of people
out.
that I work with feel like it was petty. And even
Young lady, do
the
not
secretary at the court.
interrupt me. Angel Tierra Murkerson, file number 25B.
Yes, Your Honor. Angel Merkerson.
Okay, stay right there. Who are all these people around you?
I'm at work.
So I want to just see you and we'll go from there, okay? The officer is here. He's ready to have the hearing. Do you still wish to proceed to the hearing, ma'am?
Yes, yes.
I'm going to ask you, officer, and you, ma'am, both to raise your right hands. You solemnly swear affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth, so help you God. Officer?
I do.
Ms. Merkerson?
Yes, I do.
Okay, go ahead, officer.
On March 18th of this year at approximately 9:03 a.m., I was on patrol in Brownstown Township, working in OHSP seatbelt detail. At that time, I observed Ms. Merkerson operating her motor vehicle wearing her seatbelt underneath her armpit and proper use of her seatbelt, and she was cited for the same.
Any questions of him?
You say questions. Are you asking me, Your Honor?
Yeah, do you have any questions of him, of the officer?
No, my only question was, my concern was that I had on my seatbelt and I told him me reaching for my beverage, by me being short, my seatbelt naturally wants to come here. And if it's over my shoulder, when I go to reach for my drink, it's in the way. So I thought it would be just a warning. I'm like, I got a good driving record. I did have my seatbelt on, but that was my only question.
But you can't wear it like that though, ma'am.
I don't wear it like that. I was just grabbing my beverage and I literally had put my seatbelt under my arm. Like I said, I felt personally, this is me. I'm not saying that it's right, but I felt like that should have just been a warning, being that I did have my seatbelt on when there's people that don't wear their seatbelts at all.
Well, that's not a defense. I mean, the fact that some people choose to violate laws.
But my defense is I was practicing the law. It's just that I did, as he said, okay, but it wasn't on properly. It was buckled. If I had like had it holding it with my arm, but it really wasn't buckled, then I feel like that would have been okay, that's a violation. I didn't know that me putting it under my arm to reach for my beverage would cause me to get a ticket. I had no idea. So to me, I didn't see them give people warnings for lesser things. My seatbelt was buckled up. It just wasn't across my shoulder when he.
You're not wearing it properly, ma'am. That's not wearing it properly.
Your Honor, if I may,
Yeah.
she did receive 2 verbal warnings, one for her plate or vehicle showing no insurance on it, and she received a warning for a tinted license plate cover.
My vehicle had insurance from the day that you pulled me over before then.
Wait. Let him finish.
Oh, okay, okay, no problem.
Wait.
So again, when I ran the plate during that traffic stop, it did show her vehicle was uninsured. I did not confirm or verify that because I wasn't taking action on it. She was receiving a verbal warning for it anyway. But from what I could see in my system, it was showing that her vehicle was uninsured at the time, which she did receive a verbal warning for, in addition to the tinted license plate cover that she had.
Okay, now can I speak?
Yeah.
Okay, so I have another vehicle that was registered under the same plate. So I guess in transference, the state probably didn't have it updated, but I definitely had insurance. He never asked for a copy. So to say that I got a verbal warning, he never asked for my insurance to see if I had it or not. So I don't know how, because I have proof of everything. I made sure of that. I don't drive a vehicle without having proof of insurance. I couldn't take that car off the lot without proof of insurance. The only thing he asked me was that car mine. And I said, yes, this car is mine. It's insured in my name and I am the only owner. I never got a warning about anything with insurance because we never discussed my insurance because that was never the issue. The only thing that officer stated to me was that because I asked him when he pulled me over specifically because I was praising God. I was in praise and worship listening to a Pacific song. And I asked him, I said, excuse me, can I ask you why I'm being pulled over? Because I thought I was following all proper protocol. I knew my car had been registered. I knew that I had just transferred it from another vehicle off the plate at the dealership. They said that I could use the same plate and everything was properly done. I had all that proof in my glove box. I had my insurance. So I knew I wasn't being pulled over for those reasons. So when he said my seatbelt, I was shocked.
Ma'am, did you
Yes.
hear me? I was trying to stop you. Why weren't you stopping?
I didn't hear you say ma'am. I
Okay.
hear you now.
Okay, good. All right, so listen. That insurance, I don't even need to hear about it. I don't need to hear about the tinted window. He didn't write those, but you're responsible of seatbelt violation. I'm sorry. I find you responsible $65. Can you pay that today?
No, I cannot.
When can you pay it?
I don't. I'm unsure.
Where do you work?
At a hair salon.
Well, you got to give me a date when you can pay this, ma'am.
Am I able to fight this further? Because I don't agree.
Yeah, you can pay.
Okay. Well, I
Okay.
would like to do that because I don't agree.
Ma'am. Anybody listening to this knew you weren't going to agree. Hang
No,
on.
all the people that I work with feel like it was petty. All the people that I work with feel like it was petty. And even
Young
the
lady,
support,
do
the
not
secretary at the port.
interrupt me. Do not interrupt me.
Am I free to speak or not?
No, you're not. I've already heard you. I heard everything you had to say. I'm not about to argue with you.
I'm not arguing with you, sir.
So,
I'm an adult just like you
asking you a
are.
question, and I'm going to tell you the answer. You can appeal this decision. You have to post the bond. Is it 7 days or 14 days, Lisa? Remind me.
I believe it's 7.
May 1, you have to pay by, and you tell them, I want to appeal that decision. You pay your $65, and then they will set it in front of the other judge, and you can tell the other judge your story, and maybe she'll agree with you. I don't know what else I can tell you.
That's all I need to hear. You don't have to tell me anything else. You have a wonderful day.
By May 1. Good luck to you. Thank you.
God bless you.
Thank you. Devon Michael Huff.
Thank you, Your Honor.
What is happening in this world? People think they can argue about everything. Devon Michael Huff. Or I'll let you do 25 hours of community service by October the 10th. Or you serve 93 days. So I'm going to let you do either one. You can pay 4 1/4 or perform 25 hours community service. And you either have to have the community service done or your payment completed by October the 10th. Do you understand that?
Yes.
Or 93 days. So if you don't want to pay the money, fine, do 25 hours community service. If you can pay the money and you don't want to do the community service, you pay the money, the 4 1/4, and you don't have to do community service. But one of those two have to be done by October 10th, okay?
4 1/4 meeting.
$425 or 25 hours community service. And if you don't do either one of those, you're sentenced to 90 days in jail, not 93. Do you understand that?
Yeah.
You want to do community service?
Yes.
So probation will tell you where you can do that in. Take her over there when she's done, okay?
Thank you, Judge.
Good luck. Thank you. What is going on with Mr. Racco? Who's I got Racco?
Can we get him on here?
Thomas Vernon Racco.
I gotta get him on a lock.
This case's been going on since I was a kid.
Judge, can we see who's in the jail?
Where are you, sir, in there?
Jerry Shaw.
What was the last name?
Shaw, SHAW.
You got a conflict, I see. I thought it was another one firing their lawyer.
It's a conflict.
Everybody wants to fire their lawyer, and it seems like. They don't know enough about, they know so much about being a lawyer that they can fire lawyers. That's just me. What? How you doing? Have I had the pleasure of having you in here?
So it's my first time here.
Good to have you. He's getting Mr. Racco out of lockup. How long? Okay, let me just wait. Let me be patient for a second. It's been a long morning, Lisa. Who scheduled this? I'm just kidding. It's not your fault. All right, Thomas Vernon Racco, 267-709-0682. All right, how you doing, Mr. Racco?
Hey, how you doing today, Judge?
Your name?
Thomas Vernon Racco.
Good morning, Your Honor. Calling him up. That's P8710 on behalf of Mr. Thomas Racco, who stands to my left.
So, okay, what happened? You've been on the case since the beginning, right?
That's correct, Your Honor. I was out of the office last week. That's when our office notified us that there's a conflict. We represented the co-defendant in a case that Mr. Racco was also the co-defendant on. That case was resolved last year, and so that's a direct conflict, so I left no choice but to withdraw at this point.
Does your office have any, you guys were on this from the beginning. Does your office have any? Well, I'm just gonna let it go, okay? All I know is this case been going on for about 7 weeks. It would have been nice if somebody would have told us before then. I'm gonna let you out. We're gonna appoint a new lawyer. I'll say due to conflict. Attorney Montez withdraws, allowed to withdraw. And what are we gonna do? We're gonna have to set this for September 1 now, Lisa. Have MIDC get us another lawyer. We'll make that at 1. Okay?
Figure,
Anything else on this?
nothing else.
Sir,
Ju-
anything else?
No, Your Honor.
I'm sorry,
Do you want
Lisa,
it set
was-
for exam?
Well, I think we better give the new lawyer a week to look at it. So yeah, I should also set it for exam on September 8th at 1. Right? And we'll go from there. Okay? All right, that's what we'll do. Good luck, sir. Thank you. Jerry Alonzo Mann. Alonzo Emmanuel Mann, 6B 712364. Are we doing this exam today?
We have an issue, Your Honor.
Pardon?
There's an issue.
Not another issue. I'm gonna lose my mind if there's another issue.
All
I
right.
promise everybody I'm gonna lose my mind if there's another issue. Don't tell me he's firing you.
No,
I can't wait to hear it. Just tell me your name.
James King, Athena 5229, here we have Mr. Mack, say the name correct, sir.
Gary Alonzo Emmanuel Mann.
What is the issue?
Your Honor, this morning, came to understand by speaking to the prosecutor that there are 234 items of discovery that defense counsel has not received. There was an email sent to an email account that I'm actually being associated with, that the prosecution actually sent the discovery to. I reached out to the Wayne County Prosecutor's Office.
Call in Mrs.
I'm sorry.
Where's she at?
249. He's only fired 3 lawyers, I think. Could be wrong. Maybe it's 4. Maybe they have. Somebody check with them?
I didn't.
This case is not gonna go on any longer. I don't know why. I hope I got a good explanation as to why they didn't send you this, or you're telling me they sent it to you, that you didn't get it. Mrs. Smurl is coming in, right? Mrs. Smurl, your name?
Not to me, I found out before, now the OIC and the basic officer about the.
Good.
And I do have what you said, as I did, as I did this as well.
What in the world is going on in this case? I just can't imagine what is going on in this
Right.
case.
I'm not really sure. The way we send our discovery is we have the attorneys listed by their P number and then we have their names and then we put the contact information, we copy and paste the email, just copy and paste. And I had copied and pasted in the sense of digital to Attorney King, but it turns out it was the wrong, but it was still associated with the same P number, so I'm not really sure how that even happened.
Neither am I. I've never been associated with any account in my life. I'm not. So moving to lawsuit. The only ones I've
No,
seen.
nobody has to, I take your children, you didn't get, it, right? I mean, come on. I believe she sent it. You tell me you didn't get it, I believe you both. But I am going to completely lose my mind if this case doesn't end at some time before I leave the planet or leave this bench. This has been going on. Mr. Mann here has thought that he's a better lawyer than the three previous, I believe, that he fired. We are going next week. We're going next week, and if telling you, I hope nobody's going to tell me I can't go next week. So unless you're in Tahiti or something, council, or some other beautiful place, because you got a pre-planned vacation, we are going next week,
Just, I can, what is this?
quickly.
And I apologize, Your Honor, I don't know how that happened. It's still a godsend to J King, just different ending. I don't know if we base this on.
John, get past next week. If you knew can I ask a question, council? Did you know that they were sending you all these items?
I did not. And I actually, I thought, only thing I thought was outstanding was in the police report, there was a mention of a reporting from the statement of complainant. So I reached out to their office on Friday to see that I could receive that, but I didn't know that there was the rest of the session.
There are some other 43 items, Your Honor, that were sent. And Judge the OIC did state that the other witnesses are already as well.
What time can you do? I can tell you're painstakingly looking at your calendar.
I can try to make Wednesday. I can make Wednesday work.
Pardon?
I can make Wednesday work.
No, I gotta do it on Tuesdays. they're only here on Tuesdays.
Okay, I can do Tuesday. I will. Tuesday's fine. I'll probably be coming from Third Circuit, so if it's around the same time, 11:30, that's.
I don't know, should I do this one earlier, Lisa, or is the prosecutor gonna be stuck in another courtroom? I'm kind of confused on that. I don't even know.
Are we switching to Judge Hassan next week, Your Honor?
You are.
I'm
but
looking at
I'm
her docket
keeping
right now.
this.
I will say, I know Judge Hassan does get on the bench a little bit later. We still do LCCs and pre-trials beforehand, but it's not something crazy. So if you wanted to start it earlier,
Can we do something early next week in here, Lisa?
Yeah, she's got informals at 10, 10:15, and 10:30. She has some PCCs and things at 9:30, 9:15, and 9.
I have a sense.
You want to do like
Yeah.
11:30?
He has a sentencing. What time?
11:30?
How's that?
That's what.
You sure?
Yes.
Let's do it next week. Now, are we gonna make sure that we've got appropriate emails so this doesn't happen again, folks? Did he make sure he received it?
Thursday.
You did it?
Yeah. Yeah.
September 1 at 11:30, okay?
thank you.
September 1 at 11:30. Have a great day, everybody. Thank you.
Judge, I apologize. I was just told by the Arden County witness that September 1st is actually not a good day.
What in the heck is going on? Everybody come on back in here.
Judge, it's a surgery that she has scheduled in the afternoon, so it's not just something she can move.
I got it. Okay. You don't have to apologize. I don't want anybody to apologize to me. Recalling Derry Alonso Emmanuel Mann, 260-712-3664. I thought you just asked her. Maybe I was wrong. Let's just pick another date. I'm not going past the 8th. So you better have your witnesses here on the 8th. Can they all make it here on the 8th? Can you make it here on the 8th, counsel?
If it's the same time, I do have the same stuff from 9:30. I don't stay until past 11.
Mr. Mann, are you able to make it here on the 8th?
Yes, sir.
And I'm just confirming with the other two.
I got it.
I apologize.
Hey, things happen in life. This case has just driven me crazy because we've had this scheduled, and when we were done scheduling it, we rescheduled it and rescheduled it and rescheduled it and then rescheduled it. And then I fired a lawyer or allowed a lawyer to withdraw. Then I allowed another lawyer to withdraw. September 8th at 11:30 in the morning. Lisa, is that good or not? I don't want to step on Judge Hessen's toes either. Should I make it 1?
She has an exam at 11 and 11:15 if they go.
We're going to do 1 p.m. 1 p.m. on the 8th. Okay? 1 p.m. Thank you all. Ryan Martell Fitzhugh. 26W7183992. All right, so this is gonna, good morning, Ms. Knapp. How are you?
Thank you.
Not too bad. So,
Khalil says hi.
all right, give him my best.
Well,
All right, sir, your name?
Brian Fitzhugh.
All right, your appearance, Ms. Knapp?
Rosamond Knapp, P 34696, appearing on behalf of the defendant Brian Fitzhugh.
So, correct me, they're gonna dismiss the personal identifying information, and he's going to waive count 1
He's going to waive the exam.
as the count 1, and they're dismissing count 2.
There's an habitual there that.
You're right.
Yeah.
All right. All right, sir, do you understand that? First of all, I'll take the waiver on the count 1. If you waive your right to an exam, that means you're waiving the requirement that they prove by a probable cause standard that the crime as set forth in count 1 was committed, and that you were the one who probably committed the crime. Do you understand that?
Yes.
You wish to waive that right to a preliminary exam?
Yes.
Anybody force you to do that?
No.
All right, so I'm gonna go ahead and accept the waiver. This is on the charge contained in the complaint. I'm gonna say count 1 only. Count 2, prosecutor, your name?
And good one, Your Honor, asked me, I don't know how he will be a minor.
Count 2 dismissed on motion of the prosecutor. So dismissed, count 2, motion of prosecutor. Count 1, he's found over on. The AOI date will be September the 8th. The bond was set, and that will be at 9 o'clock in the morning. The bond was set at 10,000, 10%. He's posted. Any objection to continuation of the bond, Ms. Snell? Any objection to continuation of the bond? Bond's continued, same terms. You'll be there September the 8th, sir, at 9 o'clock in the morning. I'm dismissing count 2. You're bound over on count 1. Anything else?
That's it.
Great to see you. Here we are 30, 40 years later, and I'm still seeing the same thing.
Not Bill.
I know you're not, but I am. Take care.
It's very nice to see
You too. Take care. Good luck, sir. Go down the hall. We'll give you a paper notice, okay? Thank you.
Thank you.
What do we have now? Counsel, do you have a case in front of me?
I do, Judge. I have. It's happy to do whatever the court wants, Judge.
How many courthouses you got?
Could run him back and lock him down if you want me to bring her on.
Well, I'd just like to get this lawyer out of here before I start the exam. This is gonna be a district court plea. Is that right, counsel? Wow, we're gonna vote you lawyer of the year. And armed robbery down to larceny, 200 or more, but
I would say that my mother agrees with you, you know.
200 or more, but less than 1,000 and an A and B? Is that what we're doing?
It's not a very usual type of case.
Okay, I believe you. So Lisa, I just want you to know. So we're doing larceny 200 or more, but less than 1,000.
Yes, if that's the I guess sort of two misdemeanors.
Right, I got it.
Sorry for sitting down.
People against Bronson, Kimberly Marie Bronson, 17B, 27232822. ma'am, your name,
That's Kimberly Grosvenor.
counsel, your appearance.
Good afternoon, Your Honor. Good afternoon, your staff. My name is Ted Wallace, P 0922, and I represent Ms. Bronson, who stands to my left.
All right, so as I understand it, she's charged with robbery armed, which only carries with it life. And you somehow got this reduced to a 93-day misdemeanor and a 1-year misdemeanor, correct?
Yes, sir.
So she's gonna plead to assault or assault and battery, and she's also going to plead to larceny, 200 or more, but less than 1,000 probation. They're recommending 1-year probation. Ma'am, do you understand everything that was said here?
Yes, sir.
If you plead to larceny, 200 or more, but less than 1,000, that's punishable by up to 1,000 fines, a year in jail. Costs are all those. If you plead to assault or assault and battery under a state statute, it is punishable by up to 500 fines, 93 days jail. Costs for all of those penalties. Do you understand that?
Yes, sir.
You got to keep your voice up for me.
Yes, sir.
All right, you are presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to a trial by court or jury. At a trial, you have the right to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses, and the testifier remains silent. If you remain silent, that silence would not be held against you. Do you understand that?
Yes.
Nice and loud.
Yeah.
To the charge of assault and battery, how do you plead?
Guilty.
To the charge of larceny, 200 or more, but less than 1,000, how do you plead?
Guilty.
Were you on October the 8th of 17, and I understand I'm giving you credit, but this has a lot to do, I'm sure, with this deal, probably. On October 8th of 17, were you at 19248 Gudith Road in Brownstown?
To the best of my knowledge, yes.
What did you do that makes you guilty of assault and battery?
Your Honor, may I? And
Yeah? I hope she doesn't blow this,
I
though.
understand that. So, Bronson, on that date, the judge just stated, were you soliciting, being solicited as, for prostitution?
Yes.
And during that, and at the time, the daytime, the complaint, I don't remember the name, Your Honor.
October 8th of 17th, and the victim was a James Robert Laub, L-A-U-B-E.
Did a gentleman, come to the house that you were in?
Yes.
And did you receive money for prostitution from him?
Yes.
Did you perform what was negotiated on?
No.
And was he threatened with a bat from another person in the house?
I can't state that for sure because I went in the bathroom and then I heard a lot of yelling.
Do you have any reason to disagree with the fact that he was threatened with the bat and that
No.
and you do know that the money negotiated for prostitution was not what the services were not rendered, correct?
Yeah.
You received the money, correct, ma'am?
Yes.
How much money did you receive?
Honestly, I don't
Was it more than $200?
know.
It was negotiated for more than that, Your Honor. I don't think, I think that she received some items also that were pushed up.
Did you receive items of value and or cash that exceeded $200 in value? Yes or
Yes.
no? What did you receive?
Cigarettes and some cash. It's kind of gray because it's been 9 years, Your Honor, but she received cigarettes and I think some other items
Plus cash.
of cash.
Ma'am, are you listening to me?
Yes.
Did the value of those items exceed $200 to your recollection?
Do you have any reason to believe it wasn't over to her?
No.
So you think that the items in value plus the cash exceeded $200 in value?
Yes.
And were you acting with this other person who allegedly threatened Mr. Lobb with a bat?
She was performing the prostitution part of it and negotiating for money and receiving the money after the person showed up. So
I know, but
likely-
I thought you said, correct me, she went in the bathroom at one point and somebody was allegedly threatening Mr. Lobb with a bat. Did I misunderstand?
Yes, the co-defendant in this matter was that the scheme was to lure people in, and the co-defendant came out with a bat and threat. It was the overall scheme.
Is that true?
Yes.
You were acting in concert with Mr. Koppel.
Christopher,
Is that true?
yes,
Are you on probation or parole?
no,
Anybody force you to plead guilty?
no,
I'll accept those pleas, dismiss the armed robbery. So I'm accepting the plea to larceny, 200 or more, but less. You're satisfied, right? Larceny, 200 or more, but less than 1,000. I'm also accepting the plea to assault and battery. I'm dismissing the RA file. I'm going to give you a sentence date. I'm going to continue the bond. We are going to have a sentencing date, and that will be on what day, Lisa?
September 1st. Do you want to do
Yes, was she
1
under
o'clock?
were you under the influence of anything?
was I at that time?
Yeah,
Yeah,
okay, that's fair. I'm just asking. I'm gonna order a screening and assessment.
my intake has been cleared.
Okay, I'm ordering a screening and assessment right now, and we're gonna notify the victim.
I believe the victim's here, Your Honor, if that would help.
Where's Mr. Coppola or Mr. Love? Can you come back here, sir, next week at 1?
That would be very convenient for me, Your Honor. I'm starting a new job next week.
I can allow you to get on Zoom, but I don't want to rush this, and I want to report on her.
I'll see what we can do to make accommodations, sir. I'll make, if I can use Zoom.
Yeah, we'll let you, they'll explain how to do it. September 1 at 1, screening and assessment. And we'll do that here in person, okay? And if you need to appear by Zoom, that's fine, okay?
Thank you, Your Honor.
I'll see you next week, counsel. Thank you.
Thank you.
Get them in here on McKeon, John.
Hello.
I need you guys ready in here to start on this, okay? Thanks. All right. Against,
Did we finish the plea already? Yes.
Mike,
I guess it already went on record.
I'm doing McKeon now.
I just wanted to make sure.
Yeah, the plea went through. Do I have, okay, people against Michael Anthony McKeon, 26R709-201, counsel your appearance.
Good afternoon, Your Honor. Also, we have from the people, PA 8493. Good afternoon, Judge Neighborhood Defender Service by Jackie Pilkowitz, PA 1653. On behalf of Mr. McKean, who stands to my right, Mr. McKean, will you state your name to the judge, please?
Yes, Michael Anthony McKean.
You said that with such authority, Ms. Pilkowitz.
Oh.
Good to have you, Jack.
It's good to be here, Judge. I've only practiced in front of Judge Hassan, so this is a new forum for me.
All right, well, she's nicer than me, so. All right, any preliminary matters?
One preliminary matter, Your Honor. Something that people's proposed exhibit number 1, this is going to pursuant to MCL 76611B. This is going to be the Michigan State Lab report that did show that the defendant's blood on that day. Question is 1.192 grams.
All right, the party stipulate to the admission of that, is that true?
I have no objection to it, Your Honor.
Yeah, I got it. Come on up here, bring that up. We'll have that marked and received as people's one. Any other preliminary matters?
Not with people.
Why don't you hand that to her?
Maybe.
Yes, any preliminary matters from the defense?
No, Judge.
All right, call your first witness, please. All right. Did you talk to them about sobriety court for him, counsel?
I did, Your Honor.
Wait 1 second. Did you?
Yes, I reached out for a reduction and I was denied.
What was the last conviction he had?
For OWI or for the last OWI back in 2001. But given that he had subsequent felony convictions in the interim, non-alcohol related, that was the basis for the prosecution's.
Okay. Raise your right hand. You solemnly swear affirm under penalties of perjury that the testimony you will give of these proceedings will be the whole true self you got. Could you spell your name for my reporter, please?
Last name's Korn, Koren, first name Steven, Stephen.
Thank you.
May I proceed, Your
You
Honor?
may.
Thank you. And good afternoon, is it Officer Corn?
Yes, ma'am, it is.
Officer, could you tell us where you're employed?
I'm employed with City of Rockwood Police Department.
How long have you been an officer for?
I've been an officer for over 13 years, employed with the City of Rockwood for, just over 8 years.
Were you employed as an officer on March 19, 2026?
I was,
At some point, were you at Huron River driving them on street?
I was,
Is that in the city of Rockwood County, Wayne?
it is.
Okay. Were you working alone or with a partner that day?
I was working on,
Okay, and what brought you to that area?
it was there was a call came out, from Brownstown. The possible, intoxicated driver was headed into our city. So we went over to that area.
I would object to hearsay, Your Honor.
Judges not going to straight to the matter of service, going for a weapon listener, showing why he's going to that area. Also, he's provided any other to make sure it's gonna be what he's looking for again in his investigation, so not the district officer.
As long as it's not being used, for the basis of the traffic stop, I have no objection.
Overruled. Thank you.
And Officer Corn, were you given a description of the vehicle?
I was given a description of the vehicle. I was given the color and make. I was given the color of the car and, the license plate, if I'm not mistaken, on the car also.
Okay, and were you given any other information, in the location?
Yes, the location was, vehicles coming off like West Jeff and Heron Road Drive area.
Okay, and were you provided with any other information as to what this vehicle or person could be that you, what this person or this vehicle looks like? What?
I was given a description of the vehicle, white SUV. I was given the plate and I was given a, possible description of a white male.
Okay, and did you observe this vehicle?
Yes, I did observe this vehicle in the area of, Lamont and, Heron River Drive.
And is that near the area that you provided that location?
Yes.
Okay, what did you do after you observed this vehicle?
When I observed the vehicle, I was actually headed eastbound on, Heron River Drive near Lamont. I observed the vehicle heading westbound, same location. I then turned around and got behind this vehicle and, proceeded to follow that vehicle.
And did you pull the vehicle over?
Eventually, yes, I did pull the vehicle over.
And what do you mean by eventually?
After following the vehicle and observing a few traffic violations, I pulled the vehicle over at Gossett and 4th Street.
About how long were you walking with this vehicle before you decided to pull it over?
Miles wise, it's probably about I'd say probably about a mile, maybe. If I'm not mistaken, we might even got stopped at the light, but it was a few minutes.
Okay, and you also stated that there were a few traffic offenses that you observed.
Correct. As I was following the vehicle, I noticed he had a hard time maintaining lane, which means he was swerving in the lane, hit the white line multiple times. And we turned down 4th Street. 4th Street is a 35-mile-an-hour zone. He maintained speed limit, but once we hit the 45-mile-an-hour zone, he was doing approximately 41, 42 miles an hour, according to the speedometer of my vehicle.
Okay, and then you stated that did you pull the vehicle over?
Yes, I did end up activating my overhead lights to pull the vehicle over.
Okay, did you approach the vehicle?
I approached the vehicle.
And how many people were in the car?
There was one person and one dog.
And would you recognize the individuals we saw here today?
Yes.
Did you take a look around the board and point out and tell that person was wearing?
He is wearing a gray top and black and white bottoms. He's sitting next to the fence.
And Your Honor, this time the record was so that you tried to defend this case.
The record should so reflect.
Thank you, Your Honor. After approaching this individual, you said he was the driver of the vehicle?
He was the driver of the vehicle, he was sitting on the driver's side vehicle.
Okay. What happened when you approached the car?
I approached the vehicle. As I approached the vehicle, there was a dog in the backseat. I began talking to him, the dog lunged at me. So I proceeded to ask the driver, Mr. McCann, to exit the vehicle.
Did you make any initial observations while speaking to Mr. McCann?
Yes, while speaking with him, I did notice that his eyes were bloodshot and glossy and his speech was slurred.
Okay, do you have any training experience in drivers could be intoxicated?
I do.
What kind of training and experience?
I have standard field sobriety training and my past experience also of 13 years.
Okay, have you conducted traffic stops where individuals were intoxicated?
I have multiple
times?
more than 20.
Okay, and you mentioned standardized field sobriety testing. Have you demonstrated these tests or been trained in these tests?
I have.
Okay, about how many times have you, how have you provided these tests to an individual?
Countless times, well over probably 100.
Okay, and then you stated that you made an initial observation. Based on your initial observations, did that indicate anything to you?
Yes, the glossy eyes is an indication, and bloodshot eyes is an indication of being intoxicated along with the slurred speech.
Okay, and you stated at some point, Mr. McNally was asked to exit the vehicle use of the dog.
Yes.
Did you make any other observations after Mr. McNally?
Yes, during my traffic stops, and then I do this on all of my traffic stops for OWIs. I will have them exit the vehicle and walk towards the back of the car.
Okay, and what observations did you make on Mr. McNally?
While he's walking towards the back of the car, he was uneasy on his feet, losing, which means losing balance, as he's walking towards the rear of the building.
Okay, is losing balance another indication?
Yes, losing balance is another indication of being under the influence.
Okay, and at any point, did you have a conversation with Mr. McNally?
Yes, I continued on my conversation and talking with him. And as I was speaking with him, I could actually smell the odor of intoxicants coming off this person.
Okay, and at any point, did you inquire as to this?
What?
Did you inquire as to the smell of intoxicants or the observations you were making? Did you ask Mr. McNally about it?
I did ask him if he had been drinking.
And did he respond?
Yes, he stated he had, but I'm saying he said he had to. Maybe a few beers or a few alcoholic beverages.
Okay, and then, what did you do after your test?
I asked him to, if he would be willing to conduct, field sobriety, on the spot.
And was he willing to?
At first he stated he wanted his attorney, which was, he had every right. But I advised him that we need to do this field sobrieties. So, after talking with him for a minute, he did want to do the field sobrieties.
Okay, and, what kind of field sobriety tests did you use?
So I did the Inus Agnes, which, that is a test that indicates.
And I apologize, prior to that, if I would say, you asked Mr. McEwen about the standard field sobriety test, but was Mr. McEwen going to be arrested at that time?
At that time, no, it was not.
And, you stated that you administered the HGN test?
Yes,
And what other,
I administered the HDN and the one-legged stand, and I usually do a walk and turn, but he denied the walk and turn.
You denied the law, so, okay. So were the first two tests administered?
First two tests were administered.
Okay, could you just provide a brief description of the HGN test?
The HDN test, you check the Inus Agnes, which you have to take your a point, which is approximately 6 inches away from the nose or whatever, and you go out 90 degrees, and what you're looking for is the natural twitching of the eye. The higher the blood alcohol level it is, the more the eye will naturally stagnate, so it'll naturally basically twitch.
Okay, did you provide just direction as to how to complete this test?
I did.
And did you know whether the defendant in this case understood the direction you were providing?
He did.
How did you know that?
He confirmed it verbally.
Okay, and then, what observations, if any, did you make while doing this test?
While doing that test, being within proximate, such close proximity of him, I could smell the odor of the toxins coming off of this person.
And then, was there any, observations as to the HGN test?
Also during that HCM test, he had a sway to the left and right. During the HGM test, he did, in fact, according to the SFSCs, he failed.
Why do you say that?
Because the Inus Agnes, the natural twitching of the eye was on an onset prior to 45 minutes.
And what does that indicate to you?
It indicates to me that he's intoxicated.
Okay, and then you stated that you also did the walk and turn test, or the one-legged?
The one-legged stand. The one-legged stand is a test where you hold your foot approximately 6 inches above the ground, pointing out, hands down by your side. I demonstrated this test prior to him conducting the test. When he conducted the test, he was supposed to count until I told him to stop. He counted, I think, until 4,000, and he repeated himself. He also put his foot down multiple times.
You stated earlier that you demonstrated how to conduct these assessments. Do you know whether Mr. McEwen or McEwen, I believe you saying that correctly, understood that direction?
Yes, so before I have them administer any test, I ask them if they understand the test, and if they need me to explain it again.
Okay, and you stated, were there any other observations that you made?
Just besides him, not following directions and, putting his foot down multiple times is, will be my observations that I saw.
Okay, and what did those observations indicate to you?
So the failure to follow simple directions, is an indicator of, being intoxicated and, being able to balance on your one foot pointing forward is also an indicator of being intoxicated.
Okay, and at this point, was Mr. McEwen placed under arrest?
At this point, no, he was not. We were gonna move into the walking turn.
Okay, and you stated earlier that Mr. McEwen denied the welcome turn?
Yes.
Hang on a second, where did that come? Hang on a second, where'd that come? Okay. Go ahead.
Okay, Karen, you stated that, the third test was denied,
The third test was denied. He stated he wanted his attorney.
and, what happened after that?
After that, I went to place him under arrest for OWI.
Okay, and at some point was, Mr. McEwen's blood taken?
Yes, it was. It was taken later on, after the arrest, after we got back to the station, I obtained a search warrant.
Okay, and then did you transport Mr. McEwen on the boat?
I did.
Okay, did you observe the blood draw?
I observed the blood draw.
Did you transport Mr. McEwen back to the police department?
I did.
Is there anything else that you did in this investigation?
I put all the contents from the blood draw kit into.
Whose phone is that?
Hang on a second. Whose phone is?
That was my last one, but phone's down.
I observed, I put everything into the MSP box that the blood kit comes into. I put that in there, sealed it up, my initials on it, and I had to finish put her initials on it, and later it was put into the,
You stated her initial, who's her initial?
there's a full lot of this.
Okay, nothing further was understanding.
Cross?
Officer Corin, you testified that you've been employed by the Rockwood Police Department for 8 years.
Yes, ma'am.
So you're familiar with the policies and procedures concerning body worn camera, yes?
I am.
And of course, when you are participating in a traffic stop, particularly one that may result in arrest, your policy under Rockwood PD requires that you effectuate your body worn camera.
Correct. It does.
And yet in this case, you did not have your body worn camera effectuated.
Correct. The body worn camera was effectively not working because it died on me.
And you're also aware that Rockwood Police Department policy requires that if there's a malfunction or the body worn camera dies or something to that effect during the course of a police investigation, you're to document that in your report.
Correct. I put the document that in my report.
And you did not do so here.
I wasn't asked about it. So you have to.
I'm sorry, you did not document that your body worn camera malfunctioned or was dead in your report, correct?
Correct.
Okay, now, it's my understanding that actually body worn camera and dash camera sync. Isn't that fair to say?
That is fair to say.
So when one gets turned on, the other one also gets turned on contemporaneous with it, yes?
Not at all times.
Okay, not at all times.
Correct.
Okay, so in this case, I have the dash cam, now is
Not to my knowledge.
Your Honor, I would move for ignition of the dash camera footage at this time.
Any objection?
No objection.
Defense one is admitted.
Thank
You're
you.
gonna retain that.
And I'm gonna go back to 0 seconds. What I can do is I'll play it for the witness and then Judge, I can play it for Your Honor as well. And opposing counsel if she wants to come on. I'm starting again from 0 seconds. My question is gonna be, tell me when you see him cross the fog line that you testified to on direct, okay?
I can stop you right there. I saw him hit the fog line prior when I got behind him on Heron River Drive. So the footage only goes back approximately 30 seconds from when I activate my lights.
Okay, Let's just focus on what's here depicted in the footage, okay? So we're gonna start at 0 seconds and you just tell me to pause when you see him cross the fog line.
There he touches the fog line.
Okay, so at 20, I'd say 27 seconds,
Just, yeah,
he touches the fog line. To be clear, he doesn't fully cross the
doesn't
fog
fully
line.
cross.
Okay, so one of his tires touches the fog line. And that's at 27 seconds. I'm gonna continue,
Say yes.
Yes, yes, sorry, sir, yes.
continuing playing for the record.
There again, he touches the fog line prior to the fog line starting back up.
Okay, again, it's 40 seconds for the record. And again, he's not fully crossing the fog line, he is touching the fog line with his rear tire, correct?
Correct.
All right, I'll continue playing for the record.
There again, he touches the fog line prior to the turn. Out.
Okay, and so that would have been about 58 seconds.
Correct.
I will continue playing for the record.
There again, his right rear tire touches the fog line.
Person want to see that one, but you're saying you saw it right around 108?
Right.
Okay.
Kind of see right there also.
Okay. I'll continue playing. And then, of course, this is, I believe, you pulling over the vehicle.
Correct.
In question.
This is stopped.
Okay. So fair to say, it's your testimony that about on 3 or 4 occasions, his back rear tire touched the fog line.
Correct, in that incident, yes, going northbound on Court.
And at no point did you issue him a traffic citation for touching the fog line.
No,
Do you happen to know offhand what the citation is for touching a fog line?
failure to maintain lane.
But to be clear, he never crossed into the lane outside of the fog line. He touched it with his rear tire, correct?
When you're traveling down a lane of passage, there's a yellow line and there's a white line, fog line. You are to maintain that lane, and when you start leaving in and out of traffic, that's failure to maintain.
Okay, but to be clear, he's not weaving in and out of traffic on this video.
He's not leaving in and out of traffic, no.
Okay, and your testimony was that he was swerving in the lane on direct, yes?
He's failure to maintain lane, yes.
Well, no, your testimony on direct with the prosecutor was that he was swerving. Did you
No.
not testify to that on direct?
I never said the word swerving.
Oh, okay, then I must be mistaken, but I would ask the court to take judicial notice of what it recalls by way of swerving in the lane. So you never said, if you did, that was a mistake. I don't know why you're looking at the prosecutor, but
I don't even say the word swerving. I said he crossed the line.
okay, and at no point, again, you didn't issue a traffic citation for failing to maintain.
Correct.
And then you also mentioned that he was going 41 or 42 miles an hour in a 45.
Correct.
Is that a traffic violation?
Correct, it's under the speed limits in deep traffic.
Impeding traffic for going
Under the speed.
3 miles an hour under the speed limit.
Correct.
You didn't issue a citation for impeding traffic.
Correct.
How often do you issue citations for 42 to 45?
I don't know.
I'll move on.
Well,
You can answer.
how often have you issued citations for impeding traffic?
I issue.
For driving 3 or 4 miles under the speed limit?
I do not issue, I usually do not issue them, I use them as reasons to make a stop.
And the purpose of making a stop is to issue a traffic citation.
No, it is not.
So are you saying that your purpose of your stop is to investigate criminal activity?
The purpose of my stops,
Let's narrow it back to what we're talking about here. If you're not intending to issue a traffic citation for going 41 or 42 miles an hour in this instance, then the only other plausible explanation would be that you're intending to conduct an investigation,
correct,
criminal investigation,
correct.
based on what?
Based on what I observed and the prior information that I had.
Okay, and what you observed namely is going 3 miles under the speed limit and touching a fog line with the back tire a few times.
Also crossing the line on on Heron River Drive on westbound,
Which of course is not captured by your dash cam.
unfortunately.
And again, your body worn camera, we don't know why that wasn't working either.
Correct.
Okay, now,
I'm gonna object to that portion. We do know why. It's because the body worn camera got it. It's not because we don't know.
Kind of argument.
understood, Judge.
Sustained.
Now, you testified that you have received standard field sobriety test training through the course of your time, yes?
I have.
When was the last time that you did a training course on standard field sobriety tests?
You go through one through the academy.
And to be clear, you went through one in the academy 13 years ago.
Correct.
And since that time, have you done any additional training to your recollection on standard field sobriety testing?
No,
Does Rockwood Police Department require you to fill out a form when you are conducting any sort of field sobriety tests?
they do not.
Do you have access to a form that you can fill out detailing the various tests that you performed during the traffic stop?
Object to relevance of Rockwood, the same player. It was. It's not relevant if one exists.
Well,
Wait
it
a
is
minute,
relevant.
maybe I misunderstood. Do you have, does Rockwood supply you with a form that you have access to? for
No,
that?
each officer has, you can create your own form or you can download one offline if you want, but we don't have a official form that every officer uses.
Understood. Just one moment, Judge.
Sure.
I have no further questions, sir.
Cross? I mean redirect. All right, sorry. Sorry, it's been a long morning, as you know. Redirect.
And officer, going back to the body worn camera dying, you stated it's supposed to be reported. Why is it that you didn't put it in your report, if you know?
I just forgot about it. Usually I say over the radio that my body cam has died. I am not 100% sure that I did at that time.
Okay.
That was neglect on my part.
Okay, and is it a violation of the policy, if your body worn camera does die?
There's the body worn camera dies, it's kind of out of our control. So
But is it a violation of the policy?
yes, I guess it would be, under what she stated, yes, I guess it would be a violation under the policy, but it would be up to superiors how they would want to handle it.
Okay, and, going back to the scout footage that we viewed, is everything that you saw depicted in that footage?
As far as,
You stated earlier that there was something that you saw that the footage did not depict.
yes, there was she stated it. He hit the
When you say she.
Wait, I want you to finish your statement.
At one point, he hit the fog line. And if you're referring to her comment.
I think she's talking about the Huron River Drive episode.
Yes, oh, sorry about that, yes. The point from Lamont to Fort Huron River Drive is not depicted in that in that scout game footage.
Okay, and just for the record.
And that's because you hadn't activated your lights.
That is correct, sir.
Okay, and Judge, just for the record, I want to make it clear when the officer states she referred to the defense counsel. Then I also wanted to ask, what is it that you did see that the body worn camera did, or the scout camera did not capture?
So as I've seen the vehicle coming westbound, near Lamont and Huron River Drive, made a U-turn, I got behind the vehicle. I traveled behind the vehicle, I'm gonna estimate probably about 1/8 of a mile from where I seen him to Fort Huron River Drive, and during that period, I witnessed and seen him cross the white fog line multiple times.
Okay, was that, you stated multiple times?
Yes.
And then, the portion that was shown, to the court, was that was crossing the fog line, was that just?
That was touching the fog line, yes.
And you mentioned a ticket that could be issued for that as failing to maintain your lane.
Yes,
Okay, is, Is weaving in and out or going left and right in your lane, is that something you still?
Yes, that is also failure to maintain lane.
Okay, even if you're in your lane?
If you're in your lane, there's no citation.
There's no what?
Citation.
Okay. But you stated earlier that you did observe the defendant's crossover.
Correct.
Okay. And then.
Wait a minute. You observed him crossover on Turner River Drive.
Correct, sir.
You did not observe any crossover on any of the video that the defense lawyer showed.
Correct.
He just touched the fog.
Correct, sir.
Go ahead. I just wanted to clarify.
Of course, thank you, Your Honor. And then you also mentioned earlier that you didn't issue a ticket for either impeding traffic or failure to maintain your line. Is there a reason for that?
Correct. Usually in an LWI process, it is noted that when an individual is intoxicated, they normally don't or normally wouldn't commit the violations. So we take the OWI as a higher part and we issue the OWI.
Okay, and then in this specific case, you mentioned earlier, you provided information, so when you were observing this vehicle, it was to investigate the vehicle for potentially someone intoxicated?
Correct. Safety of the public.
Okay, nothing but.
May I brief recross?
Yes.
Very brief. Now, Officer Courtney testified on direct that you followed this vehicle, this white vehicle, for about a mile, yes?
From Fort to, according to your video, yes.
Well, no, you testified on direct that you were following this vehicle for a mile, independent of the video.
Okay, correct, yes.
Okay, now, the vehicle is going, your testimony again, 41 or 42 miles an hour, correct?
Correct.
And now let's turn to the video that I did in fact admit. You effectuate a traffic stop on this video about 1 minute and 15 seconds into this video, correct?
Correct.
And if my math is correct, if you're going about 45 miles, 42 or 43 miles an hour, then a mile would take about 1 minute and 15 seconds to
Your Honor, I
travel.
object to speculation.
Approximation is the same.
Overruled.
So what you're failing to see here is that the speed limit from Huron River Drive to Mercury Park is actually 35 miles an hour, then it picks up to 45 miles an hour.
How much time were you following this vehicle before your dash camera was effectuated?
That was probably about, I'd say 45 seconds to a minute.
Okay. And so now so your testimony would be you were following the vehicle for approximately 45 seconds to a minute prior to your dash camera kicking on, yes?
Correct.
And then the dash camera is another minute and 15 seconds until the traffic stop.
Correct.
So we're looking at least 2 minutes of you following this vehicle.
Correct.
The vehicle would have to be going less than 30 miles an hour.
From Huron River Drive, on Huron River Drive, from Lamont to Fort is 25 miles an hour.
I have no further questions, Judge.
You can step down. Thank you. Call your next witness. People move the bind over.
Correct.
And
Judge, I would like to play the video that was admitted, if I may approach and.
Yeah,
Madam
sure.
Counsel, thank
you
you.
don't want to just play it on there?
It's a lot clearer, the picture here.
Come on up here.
Apologies, thank you.
Yeah, of course you can.
Oh, yes.
7:40:58. Go ahead.
I'm starting at 0 seconds for the record, Your Honor. And I'm pausing at 1 minute and 24 seconds for the record, unless the court would like me to continue further.
No,
Thank you, Your Honor.
thank you. So we left it with, you moved the bind over. And you wanted me to see the video,
That's correct, Judge.
which I had.
Yes,
Do you have any argument?
I do, Judge. Judge, I'm asking the court to dismiss all of the charges in this case because the traffic stop was invalid, as the court already and without reasonable suspicion of criminal activity. As the court already ruled with regard to my hearsay objection, any testimony concerning a suspected OWI was admitted not for the truth of the matter asserted, but admitted for its effect on the listener. So that cannot be a justification for the traffic stop when it's the people's burden to show probable cause of that a crime was in fact committed. So we can set that aside. So what we have here are two alleged traffic infractions, neither of which are really captured on camera. First and foremost, this Officer Courtroom, testified that there were a few traffic violations. I heard the testimony concerning swerving in the lane. Again, I'll defer to what the court's notes are, but I have that written down here. And that he hit the white line multiple times. On cross, he had to clarify, well, in fact, he only crossed the white line when my dash cam wasn't effectuated. Judge, I would submit that this witness is not credible. What we have here is a situation where we're trying to Monday morning quarterback a traffic stop when there in fact is no traffic violation. How do we know that? The court can see plain as day from the dash camera footage that there's no swerving, there's no actual crossing of the white line. There was no traffic citation issued as a result of this alleged basis for the stop. Coupled with that, we have a gentleman traveling at a speed of 41 to 42 miles an hour, and this officer wants to call that impeding traffic. Judge, that quite frankly is ridiculous. I don't think this court would even accept a citation for 42 miles an hour in a 45 as an impeding traffic violation. The prosecution has the burden of showing that this was a valid traffic stop from its inception, which on this record, they absolutely cannot do. And for those reasons, Your Honor, I'm asking the court to dismiss this case because the OWI and the evidence that was recovered following this invalid traffic stop needs to be suppressed as fruit of an unlawful stop of the vehicle. I would also point the court, if the court finds the traffic stop was valid, there's no evidence on this record of a resisting arrest. So that charge should just be dismissed outright. I think it's count free. There's again, no testimony at all concerning a failure to follow orders. If anything, the only orders that he didn't want to comply with were those where he asked for his attorney. So for that reason, Judge, if the court is inclined to bind over on counts 1 and 2, I would ask that it dismiss the resisting arrest for insufficient evidence. Thank you.
And Judge, just briefly as defense counsel's argument, I would also state there are a lot of traffic citations that officers can write. A lot of people don't agree with them. However, it doesn't dismiss the fact that they are still executable offenses in traffic citations are that they are.
I'm not impressed with the argument that because he didn't issue a citation, civil infraction, that somehow distracts from the probable cause or a reasonable suspicion. Let's not even talk about that. Go ahead. What else do you want to say?
Yeah, it was just going to the reasonable suspicion. I would have argued that he was provided the license plate. He was provided with a description.
You think traveling 3 or 4 miles under the speed limit is impeding traffic?
Your Honor, I can tell you, I would have to see what impeding traffic is technically considered as.
Wait, say that again?
I don't know what the statute is for impeding traffic. I don't know what it is exactly. What they're consider it. The officer did testify that that would be considered as impeding traffic, but it's not even the only reason that this vehicle was pulled over. This vehicle was pulled over because the officer in good faith believed that this individual was intoxicated. He's provided with information that information included a license plate, included the make and model of the vehicle, white model. He wasn't going after this vehicle because it was a random vehicle. He was going after this vehicle because it was a vehicle that was.
But there is no evidence on the record to that effect, is there? When you said that there was no, when you said that you weren't offering that for the truth of the matter asserted, isn't that?
However, Your Honor, would still go to the officer's good faith belief because he's provided with a location that this individual's vehicle could be at. He's provided with a license plate. He's provided with a vehicle description based on the information he's provided, regardless of whether that information was on the record or not. He conducted a traffic stop not only because of the citations, but because of the information he's provided. It is a good faith belief that this individual could be intoxicated and that he needs to investigate to potentially see if somebody is on the road intoxicated.
Okay.
It would be, even if there were no traffic stop or even if there was no ticketable offenses that were seen, the officer still has a still should investigate whether this individual is intoxicated, because there was a call that was made, there was a lot of information provided, one being the license plate of the vehicle. So it's enough for the officer to have all of that information to at least stop the vehicle to make sure this person is not under the influence of anything.
Okay, fair enough. Anything else?
Do I need to respond?
Yeah,
Matt?
if you want to, you don't have to.
No, I would love to. That's not admitted into evidence in this case. So it's the prosecution's burden. First of all, she can't cite to you the impeding traffic citation. It's her job, in fact, to actually cite the basis for the stop in this case. Additionally, she is relying on inadmissible hearsay in order to justify this traffic stop, and coupling that with a good faith exception that, again, isn't applicable here because there's nothing in this record to support that these alleged facts that she's relying on to justify the stop. So this argument is very convoluted. Quite frankly, I'm just confused as to how to even respond to it. But I think the court is picking up what I am submitting. And again, this is a preliminary exam. We rely on the evidence that is in fact admitted by this court. We don't rely on, subjective beliefs or whether he thought that he could investigate a vehicle for drinking and driving. Mr. McKean has rights that in fact are protected statutorily at the preliminary exam, and it requires the prosecution put forth this evidence to provide.
The officer had the right to pull him. And he had the right to pull him over based on multiple things. The fact that he got a call with regard to this vehicle. I do think that it's improper lane use to straddle the fog line. You're supposed to stay completely within a fog line. And still I've got testimony from him that prior to activating his siren, that the defendant crossed over the fog line. I don't know what the state of the law is right now. It used to be they could pull over somebody based on the call of a resident or a traveler, another motorist. But I think that in a perfect world, they should wait for a civil infraction at minimum to be committed before they pull them over. But nonetheless, I do think based on the information received, his testimony with regard to the defendant traveling over the fog line and allegations, and I thought he straddled the fog line 3 or 4 times when I was watching the video, that's improper lane use. He had the right to pull him over. Am I a little bit troubled that I heard this impeding traffic stuff for 41 or 42? Well, I'll be disappointed if I got officers coming in here and writing tickets to people for traveling 3 or 4 miles over the speed limit. That's not impeding traffic. If they were going 23 in a 45, that might be something. And I think some of the issue here with regard to the multiple violations, a little strong when we're talking about somebody just straddling the fog line. That being said, I'm going to bind the defendant over as charged. Defendant's bound over to the circuit court. The AOI date will be 1 week from today. Defendant's still in custody, and that will be on September the 1st at 9 o'clock in the morning. Bond has not been posted. Any objection to continuation of the bond here, anybody?
No, Your Honor. If I may ask for clarity with regard to count 3.
I'm dismissing count 3.
Thank you.
Thank you. I'm dismissing count 3. There wasn't enough testimony on that. I mean, I guess one could argue he failed to give a lawful command, but there wasn't enough testimony. And also, frankly, he had the right to talk to his lawyer. Count 3 is dismissed. So I'm just going to bond over on counts 1 and 2. Are we ready for the next exam? Is that going to be a hold 2? If it is, that's fine. I'm going to lunch though. I'm telling you, I'm not, I've been here all morning.
I was going to ask for a brief break if we could come back at 2. I don't know.
Judge, we do still have one at Wayne County on the screen, just so you know.
Would I do?
There's still one more in Wayne County.
Well, what's that one for? So I got 2 left? Is
Yeah,
that what I've got?
She's here for an arraignment. She's already talked to Corey.
Okay.
We're ready to proceed, Your Honor.
What case is that? All right, I'll do that.
Your Honor, when should I return? Just for clarification. 2 o'clock, good?
Are you guys, what kind of case is the other?
Drug possession, traffic stop, one witness.
Is that defendant in custody?
No, he's out, Your Honor.
Can I see the file, please? Let me do this arraignment. Angela Marie Socorro. This is 25B1475438 and B and C and 21W828729. Your name, ma'am?
Angelica Sakuro.
Counsel?
Attorney Corey Westmoreland appearing on behalf of Ms. Sakuro.
Good morning. She's got 3 incidents. Let me just double check something here, please. She's got an offense date of December 11 of 24. That is the operating with the presence of drugs out of Brownstown. On that same date, she picked up a possession of a controlled substance out of Brownstown. And on that same date, she also picked up a possession of drug paraphernalia out of Brownstown. So for those cases, does she stand mute and waive formal reading?
That's correct, Your Honor.
Boy, she doesn't get to show up. I think that's pretty clear. Does she work?
Yes, Your Honor. She was working, but she has been in custody since July 28th.
Where does she work?
She's working at Makeover Essentials.
She's also got a case from July 13 of 21, retail fraud. She's getting wait formal reading on that.
That's correct, Your Honor.
Where have you been, ma'am? I'm talking to you. I'd like to know where you've been. I mean, you don't show up in court here.
But yeah, it's hard for me, the whole transportation thing. I'm staying in Detroit.
Well, then I gotta tell you, if you can't come to court because you can't get a ride, then I'm gonna have to get you a ride, right? I don't like this. I don't like this at all. And if I gave you $1 million every time you came here, you'd be here. I don't even need to give you $1 million. I could give you $100 and you'd probably be here, but you don't show up. And that's not good. I don't like it. It's disrespectful. Anybody ever tell you that before?
No.
Well, I'm telling you, I think it is. Anything else you want to say, either one of you, regarding bond?
Your Honor, she is currently residing in Detroit. She was gainfully employed. She's currently on probation out of Romulus, but after speaking with her, she understands the importance of appearing and actually taking care of and clearing up all her matters.
New address. Where do you live, ma'am?
It's 7786 Braille.
Oh, that's in Detroit still, right?
Yep.
Okay, did I misunderstand? I thought you said she was living in Romulus. Did I misunderstand?
No, she's on probation out of Romulus.
I'm sorry, I did misunderstand. Shame on me. How many drunk driving she have?
This is my first one.
Allegedly.
I see some ugly things in here. Ma'am, you've missed multiple court dates on this. On the retail fraud, you're not to have any contact with employees of the Woodhaven Lowe's. You're not to have any contact with prosecution witnesses. You're not to enter 21,000 West Road at the Lowe's there in Woodhaven or any other Lowe's store. On the drunk driving, no alcohol, no marijuana, no illegal drugs. You're to attend AA 3 times a week. You cannot leave the state without the consent of the court. You cannot violate a law. You must appear in court as directed. You missed 5, 6, 7 court dates, 15,000, 10% on the OWI, drug charge and drug paraphernalia, 7,500, 10% on the retail fraud. I will give you the earliest court dates I possibly can. Lisa, we can't do better than the 2nd with Brownstown.
No, Judge Heston's off this week, so they're not here.
September 2nd at 9:45, you'll be in front of me. I do hope you can post, but you cannot do this. I'm sorry. Good luck to you. Wish you well. September 2nd, I'm doing, what about Woodhaven here? What time is that one gonna be, Lisa?
We were doing the same day.
Oh, they're both here on the 2nd?
Yeah, they're both here. Yep.
Okay, September 2nd at 9:45. One of these days, I'm gonna figure out who's here when. Good luck, ma'am. Thank you.
Thank you, Judge.
Thanks, counsel.
Have a nice
All
day.
right, let me look at this. How long is this one gonna take? You had what? How many witnesses did you have in the last case?
One.
How long did that take? Jesse Lee Carter, let's get her here. 26W 7075351 FY.
Good afternoon, Robert.
And good afternoon, Neighborhood Defender Service by Jackie Pilgowitz, P81653, on behalf of Mr. Jesse Carter.
Come on up here, sir, and when you get up to the table, would you have a seat and tell me your name if you would, please? Your name?
Jesse Carter, sir.
All right. Carter, right?
Yes, sir.
Okay. All right, we have a charge here. Your appearance?
And good afternoon, Robert. I'll see you guys now. People P893.
All right. And wait 1 second, officer. The I didn't even see this complaint yet. Give me a second. Possession with intent to deliver less than 50 grams of cocaine. Any preliminary matters, counsel?
You're on, along with hit and people's criminal reason number 1, pursuant to MCL 6611B, is going to be the Michigan State Police Laboratory report that did test items 1, 2, 3, and 4. Item 4 was that the substance that was identified was cocaine, which is a Schedule 2 narcotic, and it did weigh at 5.08 grams.
Any objection, counsel?
No objection for exam purposes.
People's 1 is admitted. Sir, raise your right hand. You solemnly swear affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole truth, so help you God.
Yes, it is.
All right, can you sit down, state your name and spell your name for my recorder, please?
Yes, it's Officer Cash, Woodland Police Department.
Okay.
Last name is spelled CACH.
You may proceed.
Thank you. Judge, would you like me to post?
Yes, I would.
May I approach?
Yes.
Thank you.
And make sure you take that and any other exhibits that are admitted and received today. All right. Thank you, officer. You can proceed.
Thank you. Good afternoon, Officer Cash. Officer, could you tell us where you're employed?
Yes, I'm employed with the Woodland Police Department.
And what do you do for me?
What do I do? I'm a traffic enforcement officer.
And how long have you been an officer for?
December of this year will be 6 years.
And were you employed as an officer on March 13, 2026?
I was, yes.
And at some point, did you do duties in Lincoln Avenue, Van Horn Road, and Marsh Creek Boulevard?
Yes, it is.
Is that in the city of Woodhaven County, Wayne?
It is, yes.
Were you working alone or with a partner that day?
I was alone.
And what, if anything, did you observe that brings you to court today?
I'm sorry, what?
What did you observe that brings you to court?
I conducted a traffic stop on my day.
Why did you conduct a traffic stop?
When I was driving on Allen Road, I just noticed the vehicle in front of me had obstructed view. So I just conducted a traffic stop like it wasn't.
Obstructed view where?
From the rear view. air fresheners, multiple of them just hanging from the rear view mirror.
Okay, is that in the rearview mirror, the back of their vehicle or the front of the vehicle?
The rear view mirror being the front windshield.
Okay, and is that a ticketable offense?
Yes,
And you stated that you conducted a traffic stop. Did the vehicle stop?
it did stop, yes,
And did you approach the vehicle?
I did.
And how many people were in the vehicle?
There's two people in the vehicle, a driver, obviously, and then a front passenger.
And would you recognize any of the individuals in that vehicle you saw them today?
I would, yes.
Could you take a look around the board and tell us if you see one with them?
Yes, I recognize the driver that day.
And what is that person wearing?
He is wearing a blue hoodie and white and gray, Air Jordan tennis shoes.
And you are on this time made a reference like Luke said that you had been vehicle.
The record should still reflect.
And what happened when you approached the driver?
Yes, I approached the driver, it's like any other traffic stop, asked for his driver's license, registration, and insurance. I confirmed the driver to be the registered owner of the vehicle. When I queried the vehicle through main and SOS, it showed that the registered owner also had warrants.
Was that before you conducted the traffic stop?
I ran the plate before, yes, I stopped the vehicle, yes.
Okay, and when you ran the plate before, did you see that the driver or the registered owner had warrants?
Yes.
Okay, and was that also a basis for your stop?
It was, yes,
Okay, and then, I apologize, did you state you were able to confirm that that's the driver, the registered owner?
yes, the driver of the stop was the registered owner of the vehicle, yes.
Okay, and was this person placed under arrest for those warrants?
They couldn't be confirmed, because by the time that, our dispatch reached out to the agency, the driver ended up having a medical emergency where he was transported to the hospital.
Okay, so what happened when you took the driver?
Yeah, I got all this information, then confirmed his identity, and I had him step out of the vehicle. He was detained just based on his warrants, and then I asked him for consent search of his person. He granted me consent to search, and then in his pants pockets where I just a large sum of money and then a clear baggie with white residue.
Okay, you stated a large sum of money. Did you count that money or do you know how much it was?
Yes, it was $1,664.
Do you recall what their denominations were?
I do not. I couldn't tell you specifics.
Do you recall, was it just hundreds or fifties or?
No, it was different denominations. It wasn't all in certain ones.
Okay, and then you also stated that you covered a baggie. Was it a clear baggie or a color baggie or?
Clear baggie, just like a traditional Ziploc bag, clear baggie.
And what was inside of it?
White powdered residue.
Okay, and was that significant to you in any way?
Yeah, it's consistent from my training experience with narcotics.
Okay, and what is your training experience in narcotics?
I've been through numerous schools of drug and addiction, and different street cop training with I'm trying to think of the specific class names on it, but the vehicle circuits. Yeah, I couldn't say any more specific schools off the top of my head right now.
Okay, you've been to multiple classes.
Correct.
Okay, have you conducted investigations in narcotics?
Yes.
Okay, about how many do you have?
10 to 15.
Okay, and you stated earlier based on your training experience, you believe this to be suspected narcotics?
Yeah, I did this.
Okay, what did you do after you observed this?
After I observed that, I went back up to the vehicle, or excuse me, before that, Officer Meadows arrived on scene as my backup officer.
What was the name of the officer?
Officer Meadows.
Okay,
Yeah, he arrived on scene. He was in his own vehicle just to guide me up on the stop. The driver was,
additional officers?
I'm sorry.
Did you call for additional officers?
I believe I did. So he arrived on scene, the driver was placed in the back of that vehicle while he was detained. And then I went up to the front passenger and I had her step out of the vehicle.
Okay, why did you have to step on the vehicle?
Based on finding paraphernalia or evidence of drug use in the car, we're going to search the car.
Okay, and at any point was Mr. Clarence arrested?
Yes.
At what point, you know?
After we searched the vehicle and discovered additional narcotics inside the vehicle.
Okay, so when you initially discovered this, bag in his pocket, was he being only detained?
At that point, yes.
Okay, and then you stated that you conducted a search of the vehicle. Did Officer Meadows assist you, or were you the only one conducting the search?
I conducted the search. Officer Meadows was with the driver and passenger.
Okay, what is it that you found?
It was a bag of white pills that were found on the.
You said a bag of white pills that were found. Is that what you said? Bag of white pills that were found?
Correct.
Where?
They were on the passenger front seat. And then on the floorboard, there was also 2 suspected firearms on the passenger side floorboard.
Okay, and, going back to the item that you spent in the pocket, you stated that there were, passenger, rocks. How was the consistency of the bag that you found? Inside the pocket of the defendant, what was that consistency? Was it hard rock or was it blue powder?
So the bag that was on the driver, is that what you're
Yes.
asking about? That, it was a white, like dry powder substance.
And was that item recovered in connection with evidence?
It was, yes.
Okay, and then the items, those 2, suspected regarding the crime files, were those also placed into evidence?
Yes, they were.
Okay, and then what happened after that?
After that, I went to the passenger who was outside the vehicle after the pills were discovered, and informed her that she was going to be under arrest for the possession of the pills that she was on top of.
Okay, and where did you say those pills were found?
They were found on the passenger front seat.
Okay, and, do you recall, did that bottle have a name or anything?
Oh, there was no bottle. The pills were in a clear bag.
Okay. And then what happened after that?
After that, I spoke further with the passenger in the vehicle, who stated she had additional.
Objection, hearsay.
And the judge is not going for the non-reserved, it's just going for your button listener.
That cannot be.
Former rule, I'm sorry, sustain, go ahead. Ask your next question.
And officer, you stated that you spoke to the passenger and you received information.
I did, yes.
Okay, that's it with that. What did you do?
There's more evidence collected,
Okay,
And
what kind of evidence?
additional narcotics,
Okay, and where were those?
on her person.
Okay, and where on her?
They were tucked, in her. I guess crotch would be the best way to say that, but
And
between her legs.
how were those items packaged or that item packaged?
Both of those baggies were also in a clear baggie that were just tied.
Okay, were all the bags that you found were all the same type of bags, just clear bags?
Correct, just clear bags that were ripped and tied together.
Okay, and could you describe the item that was inside the bag that you found?
Yes, so the 2 additional bags,
Yes.
so there's the one that was the clear bag of pills. And the 2 additional bags were another white substance, one was a little louder than the other.
Okay, and, did that appear to be similar as to the one that's found on the defendant, Mr. Carter?
Yes,
Okay, how?
again, it just had that same white powdery consistency.
What did you do with that?
After that, I continued to search the vehicle, didn't find anything additional. The vehicle was towed, and then again, the driver ended up going to the hospital for medical emergency. And then the passenger was arrested and brought back to the station.
Okay, and was that vehicle towed?
It was, yes.
Okay, and then, although going back to your experience in narcotics, you can know the differences between personal use and void, right?
I'm sorry, between what?
Personal use and void, right?
Objection's gonna call for a legal conclusion in the court in the best position. to be.
Overruled.
Your Honor, may I rephrase the question?
Yeah, sure.
Thank you. And you stated earlier that you have training and experience in narcotics. And you mentioned that you take classes. Do you know the difference between using something for personal use or in something such as sales? What kind of things indicate that to you?
Yes, for the quantity, there's also different things that are.
Yeah, I don't know. I don't know about this. You might be right about that. Why are we talking about this? Just ask him factually. I'm gonna sustain the objection, strike that testimony. Just ask him factually what he saw that you think is gonna show that the defendant had intent to deliver. Whether it's the packaging, whether it's the quantity, whatever it is. Okay,
Thank you.
thank you.
Okay, so you stated earlier that you were able to recover a significant amount of money on the defendant. It was around 1,664, is that?
That's correct, yes.
Okay, is that a significant, and you stated earlier it's a significant amount, why is that not significant, or what does that show to you, if anything?
Yes, I believe it's a significant amount of money because been dealing with the public, making arrests or just doing the course of my job. I would say most people have less than $1,600 cash on their person for either shopping or anything, just day-to-day life. I
Okay,
would say that would be more an above average amount than a normal person would carry on a normal day.
okay, and do the denominations of the amount of money or the type of bills that there are, does that have any significance?
Again, all of the bills were different denominations from, like I said, it wasn't all one denomination, they were all different. It would have been, say it's,
Are the bills being different, is that significant to you, or the different denominations?
Dr. Master answered.
Overruled. Answer that one more time. Make any difference to you as to whether or not the denominations are high or low? No. Okay.
Okay, then did you do anything in your investigation following that?
I'm sorry, one more time.
Did you do anything in your investigation following that? After the defendant was arrested or taken to the hospital, did you do anything else?
I did, yes. So after the driver was taken to the hospital, the money was taken into evidence, and that he was served with the forfeiture for the cash.
Nothing good.
Trust.
The Officer Cash?
Yes.
Okay. So you testified that you stopped this vehicle because of an obstructed view of the windshield?
That's correct.
And by obstructed view, you mean there was an air freshener dangling from the rear view mirror, correct?
Correct.
And we're talking about standard size air fresheners you can purchase at a gas station.
Correct.
I was just asked to approach with the still of his body worn camera judge. And copy. I'm just gonna show him still. May I approach,
You
Ryan?
may.
I'm just gonna approach at a clip from 48 seconds. So when you mean a obstructed view, it's your testimony that this little evergreen tree is obstructing the view of the entire windshield?
I wouldn't say it obstructs the entire 100% of the windshield.
Let me see it too. Will you turn it this way? Go ahead.
So I guess I'll re-ask, it's your testimony that the basis for the traffic stop was that this dangling evergreen tree was obstructing the driver's view.
Correct.
You testified that the registered owner of the vehicle had warrants.
Correct.
Okay. To be clear, prior to effectuating your traffic lights and conducting the traffic stop, you did not know who the driver of the vehicle was at that time.
Correct.
So you pull over this car for two reasons. One is this evergreen tree dangling in the rear mirror, yes?
Correct.
And two, an unknown registered owner of the vehicle who we don't know is in fact driving, popped up when you searched them prior to effectuating the traffic stop.
Correct.
Okay, and then in fact, you testified you weren't even able to verify the warrant after the fact, correct?
If the agency would like to pick them up, correct, it's correct, they never responded saying whether they would like to advise and release or come and take in custody of the individual.
The identity of the person for whom the warrants were issued was not known to you until after you effectuated the traffic stop.
One more time.
Yeah, you did not know that the driver, in fact, had outstanding warrants until after you effectuated the traffic stop.
Correct. I didn't know who the driver was until I went up and confirmed his identity.
Okay. Now, at some point you ordered the driver out of the vehicle, yes?
Correct.
And you testified that was for these outstanding warrants, yes?
Correct.
And you searched this person, yes?
Correct.
And you recover $1,600 in cash.
Correct.
And then you recover a plastic baggie that has some suspected white residue on it, correct?
That's correct, yes.
There's no rocks inside this baggie.
There are rocks.
There's no, I mean, when you say residue, you mean what appeared to you just to be stuck to the outside or the inside of this plastic bag, correct?
Stuck inside the bag.
So any of the narcotics that you ultimately recovered that were actually sent for testing in this case were in fact recovered from the passenger of the vehicle, correct?
The narcotics were, yes, on the passenger, but the baggie that was found in the pocket was also sent to the lab.
But that in fact was not tested to your knowledge.
To my knowledge, I'm not sure exactly what items were.
And you're referring to the plastic baggie with the white residue?
Yes, Your Honor.
Now, I want to talk a little bit about the passenger. To be clear, that plastic baggie with the suspected white residue is the only evidence of narcotics that you've actually found on Mr. Carter's person, correct?
Correct.
Now, let's turn to the evidence that you recovered from the woman sitting in the front seat. You said that you recovered suspected narcotics or pills on the passenger seat underneath where she was sitting, correct?
That's correct.
And then you also recovered suspected narcotics. Was that in powder or pill form wedged between the passenger seat and the passenger door?
The pills were found on the passenger seat, and the additional 2 baggies were on her person between her legs, and then on the passenger side floorboard for the 2 suspected crack drops.
Okay, so wait a second. I want to make sure I understood. Pills were located on the passenger seat, correct?
Correct.
Located 2 baggies with narcotics in her crotch area, correct?
Correct.
And then there were others found on the passenger floorboard?
Correct. 2 suspected drops, yes.
And were they tested?
To my knowledge, I'm not sure what exactly the lab tested. I know they only tested a portion of what was submitted.
Okay.
And to be clear, when you say the passenger floorboard, it was wedged, I guess, on the floor between the passenger seat and the door, not at the feet of the passenger, correct?
For what item?
The 2 baggies.
Yes.
There were 2 in her crotch. There were 2 between the seat and the passenger door, right?
So there was 2 baggies between her legs. There was the bag of pills on the passenger seat, and then 2 loose rocks on the passenger side floorboard.
Now, to be clear, one of the items that you recovered from the passenger was this one knotted clear plastic bag holding white material, correct?
Correct.
That was recovered from the passenger.
Correct.
That was not recovered from Mr. Carter.
That's correct.
Just one moment, Judge.
Take your time.
I have no further questions.
Redirect?
Thank you, Your Honor. And you stated earlier that the owner of the vehicle had insurance.
That's correct.
And was that one prior to the stopping conducted?
Yes, I ran the plate and got information about the registered owner before the vehicles.
Okay, and I just want to clarify, were the warrants confirmed when you stated that the agency had not yet confirmed whether the Mr. Carter was going to be picked up or not? Was that saying that, did you know whether these warrants were confirmed or whether?
The warrants are valid on face value.
Okay, so when you stated that you were not sure of it being confirmed earlier, was that because you did not know the agency wanted to pick Mr. Carter up?
Correct, I was unsure if they were gonna pick him up or wanted me to advise and release him onto the warrant.
Okay, but the warrants were confirmed and were valid.
They were bad, yes.
Okay, okay, nothing further, thank you.
Any other questions?
To be clear, you did not know Mr. Carter was driving the vehicle prior to effectuating the stop.
Correct.
No further questions.
You can step down. Thank you. Call your next witness.
None further witnesses.
People move the bind over.
That's correct.
Any argument?
Yes, Judge. Oh, for the people,
Either one of them.
I don't know.
I'll reserve for rebuttal.
Okay.
First and foremost, again, we're in the same position. There's no basis for this traffic stop. The invalid stop, one.
I'll lose on that one.
I'll make my record, Judge, but I can sense where the court's going with the stronger argument, so I will move on there. The obstructed view is absolutely ridiculous. In no universe could this court or any court find that a dangling air freshener obstructed the view of the driver. With regard to, and so that cannot be the basis for the traffic stop in this case. With regard to the fact that the registered owner of this vehicle had outstanding warrants, the problem is that we didn't know who was driving the vehicle before the stop. The police must have reasonable suspicion at its inception prior to turning on their traffic lights in order to effectuate this traffic stop. They had no reasonable suspicion to believe that the driver of this vehicle, in fact, had outstanding warrants. I'll move on if that's not where the court's going. The bigger issue is there's no drugs found on Mr. Carter's person. The people have presented and what's been admitted as People's Exhibit 1 is the laboratory report, which shows that one of the substances tested positive for cocaine that was found on the passenger of this vehicle. All of the evidence was linking to the passenger in her crotch area, in her seated area, and also between the passenger door and the passenger seat. There is no other evidence of narcotics on or about Mr. Carter's person. There's no statements that he made that would suggest that he knew that the passenger was carrying these illicit substances on them. What they found was a plastic baggie on him with suspected residue that was not even tested. And how do we know that? Because the People's Exhibit 1 of the laboratory report, we don't have any confirmation that there were narcotics or any substances found on or about Mr. Carter. This arguably is all falling on the passenger. I don't even see how by a probable cause standard, we can link these drugs to Mr. Carter. He was carrying cash on his person. Okay, all right. And I understand, sometimes when you have cash coupled with drugs and other indicia of sale, that it could arguably go to possession with intent to distribute. The problem is that people can't establish possession. They don't have possession and therefore.
Can you make your state? If I let you finish.
You have, yes. That could be done.
Anything else?
I would just state that there is a valid basis for the stop, even the driver had warrants that most definitely gives some reasonable suspicion to stop the vehicle to check and see if this person is the person who has the warrants and then arrest them. I would also state that it could be circumstantial evidence, but we do have here similar bags that were found on the defendant. Understandably so, the passengers, the one who had the narcotics on them. However, showing either similar bag showed that these individuals were working together. Also, there were large nominations could go to a delivery, which could show a question of fact for the trier of fact. And also the rocks, the two suspected crack cocaine rocks on the floor of this individual's vehicle as well. And Your Honor, possession doesn't have to be one singular person, more than one person who possess something. It would show this individual what they knew about it. And then given that they are just on the passenger floor of his vehicle, could show that they would know about it. And that is all, Your Honor.
As much as I hate to admit it, I think that still is obstructed vision with the Dame and Lauren. I've thought that's silly for years, but the law would state that is obstructed vision. That does give an officer right to pull somebody over. I do have a problem with the possession with intent to deliver here. You got a guy with a lot of cash, a baggie with a little bit of residue, and you got his pass.
This courtroom hearing centers on Jalen Hendricks, a young man already on probation in 2 separate felony cases involving evading arrest or detention with the use of a vehicle. But now, both of those cases are back before the court because motions have been filed to revoke his probation. And instead of a sentencing hearing, the immediate question is whether the judge should set bonds that could allow Hendricks to be released from custody while the revocation cases continue. As Hendricks takes the stand, his attorney begins building a picture of his personal background. Hendricks explains that he grew up moving from group home to group home while in CPS care. He says that his only local family is his grandmother, although he also has a fiancée. When asked whether he owns any valuable property that could help him secure a bond, the answer is no. The court then examines his financial situation and learns that he shares a bank account with his grandmother with approximately $1,000 in it, and that their income comes from Social Security benefits. The judge then gets directly to the most important question. If a bond is set, how much money could Hendricks and his family realistically come up with? Hendricks estimates that he, his grandmother, and his fiancée might eventually be able to gather between $2,000 and $3,000. His attorney suggests that this could support a bond in the neighborhood of $20,000. But there is one major problem. Hendricks admits they do not have that money available immediately. Even if the judge agrees to set a bond, he would likely have to wait for his family to gather the funds needed to secure